Pro-forma parties. So, who is a pro-forma party? A nominal or pro-forma party is one who is joined as a plaintiff or defendant not because such party has any real interest in the subject matter or because any relief is demanded, but merely because the technical rules of pleadings require the presence of such party on the record. Aside from indispensable and necessary parties, there is a third set of parties, the pro forma parties, which are those who are required to be joined as co-parties in suits by or against another party as may be provided by the applicable substantive law or procedural rule. An example of a pro forma party is provided by Section 4, Rule 3 of the Rules of Court, spouses as parties. Let's look at this example. The rule provides that husband and wife shall sue or be sued jointly except as otherwise provided by law. Now, what is the effect of a non-joinder of pro forma parties? Pro forma parties can either be indispensable, necessary, or neither indispensable nor necessary. The third case occurs if, for example, a husband files an action to recover a property which he claims to be part of his exclusive property. The wife may have no legal interest in such property, but the rules nevertheless require that she be joined as a party. In cases of pro forma parties who are neither indispensable nor necessary, the general rule under Section 11, Rule 3 must be followed. Such non-joinder is not a ground for dismissal. Hence, in a case concerning an action to recover a sum of money, the Supreme Court held that the failure to join the spouse in that case was not a jurisdictional defect. The non-joinder of a spouse does not warrant dismissal as it is merely a formal requirement which may be cured by amendment. Conversely, in the instances that the pro forma parties are also indispensable or necessary parties, the rules concerning indispensable or necessary parties, as the case may be, should be applied. Thus, dismissal is warranted only if the pro forma party not joined in the complaint is an indispensable party. So in the case of Quezon versus Carretero Albano, the Supreme Court ruled that Quezon's wife was a pro forma party to the complaint whose joinder is merely a formal requirement, the non-observance of which may be cured by amendment. Dismissal is warranted only if the pro forma party not joined in the complaint is an indispensable party. But remember the rule that it is not an outright dismissal. The court shall order the joinder of the indispensable pro forma party. And after failure to object or failure to obey the order of the court, then it can be a ground for the dismissal of the case under Rule 17 for failure to obey the order of the court.